The UDRP, or Uniform Domain Name Dispute Resolution Policy, was created as a tool for trademark owners to fight back against cyber squatters on the internet. Indeed, the policy is only available to trademark owners and only under certain circumstances. But what type of trademark is sufficient to invoke the UDRP, and is a trademark registration required? Hi, I'm Doug Isenberg, an attorney and founder of GigaLaw, a law firm that helps clients protect their brands on the internet. In this video, I'm going to talk about a fundamental issue in the first of the UDRP's three-part test, which relates to trademark rights. The first element of the UDRP says that a complainant, which is the person or company filing the dispute, must prove that the domain name at issue is identical or confusingly similar to a trademark or service mark in which the complainant has rights. Interestingly, this single test actually consists of two parts. First, the complainant must have rights in a trademark. And second, the domain name in dispute must be identical or confusingly similar to that trademark. In this video, I'm focusing just on the first part, trademark rights. Interestingly, the UDRP says nothing about where those trademark rights have to exist. In other words, a trademark owner can have rights in the United States, in the European Union, or in almost any country or geographic region. And that's regardless of where the parties to a UDRP dispute are located. So even if, for example, the domain name registrant is located in China, the UDRP doesn't care if the complainant only has trademark rights in the United States. This is made clear in an important document called the WIPO Overview, a publication about the UDRP from the World Intellectual Property Organization, the leading provider of UDRP services. The WIPO Overview says, noting in particular the global nature of the Internet and domain name system, the jurisdiction where the trademark is valid is not considered relevant to panel assessment under the first element. So, all that matters is the complainant actually has trademark rights. Now, there's at least one important exception to this rule: state trademark registrations in the United States. In other words, a registration only within a specific state and not at the federal level with the U.S. Patent and Trademark Office. State trademark registrations are usually insufficient for purposes of the UDRP. And that's because many U.S. states automatically grant trademark registrations upon application without providing a substantive review. Or, as one UDRP panel wrote, because state registrations are issued with no examination, a state registration does not give rise to the same presumptions of validity and ownership as does a federal registration. Importantly, it also doesn't matter, at least not for purposes of the first element of the UDRP, when the trademark owner's rights arose. I've successfully represented clients in UDRP cases who own trademark registrations that are more than 100 years old, but I've also successfully represented clients in UDRP cases with very new trademarks. I've even represented clients who obtained their trademark registrations even after the disputed domain name was registered, although that's a very unusual situation with facts that don't often arise in domain name disputes. Now, the date of a trademark registration may be highly relevant to the second and third elements of the UDRP, but for purposes of establishing trademark rights under the first element, timing is not important. So, now that we've addressed the when and where of trademark rights, the question I often get from clients is whether a trademark registration is required under the UDRP. This is important because it's actually possible to establish trademark rights without obtaining a trademark registration. This is typically referred to as a common law trademark. Most sophisticated companies and smart business owners, as well as many individuals, understand the importance of trademark registrations, but not everyone does. Plus, trademark registrations can take a long time to obtain, typically a couple of years in the United States, depending on the jurisdiction. So, if a company or person has never applied for a trademark registration, or has applied, but the application is still pending, does that company or person own trademark rights for purposes of filing a UDRP complaint? The answer, like so many answers in the legal system, is it depends. Here, it depends on whether the company or individual has actually obtained common law trademark rights and whether it can establish to the satisfaction of the UDRP panel that it has done so. Because unlike with a trademark registration, there is no registration number to cite or single document to provide to establish common law trademark rights. The WIPO overview says a complainant must show that its mark has become a distinctive identifier, which consumers associate with the complainant's goods and/or services. And then, the WIPO overview lists 5 types of evidence that can demonstrate this required type of distinctiveness, or what's called secondary meaning in trademark law. First, the duration and nature of use of the mark. Second, the amount of sales under the mark. Third, the nature and extent of advertising using the mark. Fourth, the degree of actual public recognition, such as among consumers within a specific industry or in the media. And fifth, consumer surveys. Now, there's no specific way to apply these factors, so whether a complainant can actually prove that it owns common law trademark rights will depend on the specific facts and the strengths of the legal arguments in each case. In appropriate cases, proving trademark rights should not be a difficult task, but failing to do so will be fatal to a UDRP case. So it's essential to understand this very first part of the UDRP's very first test before filing a complaint. To learn more about domain name disputes, I invite you to take a look at other resources on my website at www.giga.law, where you can also subscribe to receive a daily email newsletter about important developments in internet law. Thank you.